The people of the state of Michigan versus Ashley Page Barnhill. And this is the People's Emergency Motion regarding bond.
Thank you, Your Honor. We got a very disturbing voicemail from the father of this child, who is also the victim in this pending case, really begging for somebody to do something because CPS wasn't doing anything.
And that is not a surprise.
Correct.
Were they called?
Yes, yes. And what I'm asking for fundamentally here, Judge, is that you revoke her bond. And I will go through all of the reasons I think that is absolutely necessary in this case, not only to keep the community safe, but to keep these children safe. Because this defendant is a danger to not only her children, but to any child. Your Honor, I actually remember that case when I was your docket prosecutor a few years ago. And why do I remember that case, Your Honor? It was a CCW, but there was another component to it. Because the victim's, the child's father, right, who's the victim in this case.
Was the victim there?
Yes, because he called police and said, this defendant tried to hit me with her car. We couldn't proceed on that count because he didn't want to get her in trouble. You know, he wanted to work things out with her. She was 12 weeks pregnant at the time. So she's driving a car allegedly, trying to hit the father of her soon-to-be child, which is the victim now in this case. And how does that argument start, Your Honor? Over marijuana, over weed. And I'd like to point out that I read her the PSI for that case, and she told this court and the PSI writer, oh, I stopped marijuana. I stopped all of that when I found out I was pregnant. Incorrect. By her own admissions, at 12 weeks pregnant, she's trying to get marijuana and ingest marijuana. So now let's talk about the case that she's currently on bond for. Okay, this is a child abuse third case. And how does this start about? The child, and not just a child, we're talking about a 12-month-old baby, right? So she gets into it with the father of this child. He's making some sort of cake for someone's death. And she's mad that he's spent money on that cake, probably because it's taking money away from, I don't know, maybe some illicit substances. So what does she do, Your Honor? She throws the cake to the ground, and then he grabs her phone, and in an effort to get her phone back, she uses the 12-month-old baby as a bargaining chip, grabs that baby so tightly around the arms that it leaves red marks on the arms of this 12-month-old.
So we're barely seconds into this hearing, and the prosecutor comes out swinging, not with a routine bond argument, but with an emergency motion tied to a voicemail from the child's father. That's already a rough start. Then we hear about an older case where she allegedly tried to hit him with a car while pregnant. Over marijuana. Bro, we're speed-running bad decisions. And when the prosecutor starts describing a 12-month-old being used as leverage during an argument, look at the judge's face. That expression just went from curious to deeply concerned. And trust me, it's about to get way worse.
Can I interrupt you? Was she with the victim? Because there's a no contact order. Is that how she knows about the cake and throws the cake?
If there was a no contact order as part, so the cake incident is those facts are why she's on bond right now, to Your Honor. And I don't believe there was a no contact from the CCW.
Okay.
Does that make sense?
Yes.
And he takes the kid, and what does she do in response, Judge? She takes 2 knives, follows him, tries to get in his face, and then begins stabbing the walls while the child is still there. Over what? Money? I mean, that's so what I'm saying, Your Honor, is that is incredibly dangerous behavior, right? We are seeing an escalation. We're seeing this pattern of violence. We're seeing this pattern of her putting herself, her needs, her wants above children, above her own child, and above a baby. Between June 6th and June 7th, the child is now 14 months old, was admitted to the hospital for a marijuana overdose, okay? And this 14-month-old was asleep for 15 hours, which Your Honor knows well with children, that is incredibly dangerous. They need to eat every 3 to 4 hours. And the fact that that baby is completely asleep for that amount of time is very dangerous. And so how do we find out about this? Well, it's not the defendant telling CPS. Nope. It's not them telling the father. Nope. In fact, there's kind of sort of this cover-up where the dad is saying, when can I come get my child? And on that Saturday, grandma is saying, oh, we might have a birthday party the next day. Oh, I don't know if she can come home while she's in the hospital. Grandma, right, who this defendant had told you can be the supervisor for this child, right, when she has contact with this child. On June 12, 2026, she told CPS that she had expressed to both the victim, the baby's father, right, and this defendant, she'd already expressed to them that she no longer wants to supervise the visits because she is too old and has a life of her own. When they discussed with her the marijuana, she advised she uses edibles and her estranged husband smokes. CPS asked her if marijuana is kept in the house. She said it's in her bedroom. They asked if any could have dropped that the child could have gotten into or been in her bedroom. She said it's possible because there are always a lot of kids running around the household and she can't keep up. She stated everyone uses marijuana and she treated the situation as less significant than it was. So I'm not sure what kind of weed funhouse we've got going on here, but it's completely unacceptable. They interviewed her on June 8th, right when the child had gotten out of the hospital.
Wait, so after the cake fight, the knives, and the screaming, now we're talking about a 14-month-old ending up in the hospital from a marijuana overdose? Nah, the prosecutor isn't just making accusations here, she's building mountain. Then Grandma enters the story and somehow manages to make everything more chaotic. Marijuana everywhere, kids running around, nobody watching who's grabbing what. I mean, this sounds less like a childcare plan and more like a reality show that got canceled after one episode. Meanwhile, the judge is sitting there with that "you cannot be serious" look. But then CPS gets involved.
And just so we're clear, Judge, Grandma actually told this defendant, you gotta take her to the hospital. Why? This 14-month-old is lethargic. Her eyes keep rolling back in her head. She's not able to walk and she refused a bottle. Where's the defendant? Where is she to notice this? Why isn't she taking this child to the hospital? Why doesn't anybody care?
This is bond conditions. On the other file, she's not to be in the presence of any third parties who have marijuana. CPS is involved now?
CPS is involved, and I want to talk a little bit about that next.
Okay.
So they did actually meet with mom, defendant, and grandma last night. Mom is refusing, defendant is refusing to adhere to a safety plan. They said, please leave, take this child, put this child with a relative. And what does this defendant do? She says, I'm not giving the child back to the dad. Nope. Here are 2 names of relatives that the kid can stay with. Doesn't provide a last name. Provides an address. It's the same address as grandma. Grandma who has told CPS, this is too much for me. Grandma who has said there's marijuana everywhere in this house.
Now let me interject that my order of April 15th says very specifically, ma'am, because you just put up your hands like this, like something's wrong here, and I'll wait to hear from you, but it says, follow all family court orders, recommendations, and all recommendations of CPS. That would be a recommendation from CPS is what you're telling me, is that correct?
Absolutely.
Thank you.
Absolutely. She's not complying with the safety plan because guess what? They said put the child with a relative. And you know what? Where was the child last night? Still with mom, still with grandma. It's not with somebody else. And also, interestingly enough, they asked her, hey, will you take a drug screen last night? She says, no, I'm not taking one. She says, I'm taking one tomorrow. Which I guess, I don't know.
Did she take one?
She did not.
Okay, guess what we're gonna do right now? We're gonna take a break. Ma'am, you're going downstairs for a drug screen right now.
I asked that an officer.
I'm gonna just ask the deputy. Can we have a deputy escort her down to probation for a drug test? Thank you.
Probation.
Thank you. And you administered a drug test. Was it positive for anything?
It was negative for amphetamines, cocaine, fentanyl, methamphetamines, opiates, oxycontin, and tramadol.
However, you don't test for marijuana anymore?
We don't have those on our instant tests. No.
The sample that she gave, can that be sent?
This cannot. We could urine test her and send that one out, or we could send her to EverHealth and have her test today.
Oh, she's not going anywhere, I think, but we'll see. But she could give another sample and we can test
We can
that.
do a urine sample.
All right. Appreciate doing that. Thank you very much.
Yes.
And here's where things start getting really uncomfortable. CPS tells her to place the child with a relative, and according to the prosecutor, she basically says, yeah, no. Then comes the moment nobody saw coming. CPS asks for a drug test, and she refuses. Refuses. Bro, that's like showing up to a swimming competition and saying you're allergic to water. The judge leans forward, folds his arms, and suddenly decides we're not waiting until tomorrow. Drug test. Right now. The room gets real quiet, because everybody's wondering the same thing. What happens when those results come back?
And Judge, I think there was I don't know if the court received an email from probation downstairs regarding a statement this defendant made downstairs about, we'll see what happens, we'll see what's on the test. So it's not like she's even denying that something would come up. Further, she refused to be tested yesterday by CPS. You know, of course, I'm conjecturing at this point, but if she really had nothing in her system, what would she have to hide? For all those reasons, I'd ask that you revoke bond. If you are inclined to not revoke bond, I have a whole list of conditions I would ask that Your Honor put on, like that she immediately hand that child over to CPS immediately.
Where is the child right now?
I presume with grandmother at the house.
So father was denied picking the child up?
Correct.
Okay.
Correct.
Okay, well, let's not get to those requests right now. Let me hear from the counsel and defendant. Sir, if you could come up to the podium with your client. Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any illegal drugs, marijuana, alcohol yesterday or today?
You want me to be honest? Yeah, I
want you to be honest. Otherwise, it's perjury.
I thought, I don't know what I was coming here today, but I was scared and I smoked yesterday. Someone handed me a joint and I hit it.
And you understand that's per probation and bond conditions, no marijuana, not to be in the presence of it, not to use it.
I am aware, Your Honor. Yes.
Okay. And are you still feeling the effects of the marijuana?
No.
Are you supposed to be on medication that you're not on?
Marijuana. I have a med card and I'm on bond, so I'm not allowed to smoke.
Well, you
So I
are,
haven't been, but
you
I
are
messed
with,
up yesterday.
ma'am, you are with the medical card if you gave that to probation. Did you give that to probation?
Yes, I did.
Well, did you use it as prescribed or not?
Yeah, I believe. I mean, I haven't been using it as prescribed because my lawyer told me my bond I couldn't.
Well, you can, except that for medical reasons, you can. I'm not a doctor, I don't override doctors, but that was not even raised to my knowledge. But okay.
And I've been emailing Ms. Wanji trying to get her to talk to you about that. She won't return my phone calls, my email. But I haven't heard from her.
You have pretrial services and you also have a probation agent.
Yeah, and she told me my lawyer needed to amend my bond conditions. I'm not allowed to smoke while on bond probation. They don't, So she talked to my lawyer and said they need to.
Okay.
I have not been the attorney of record for this, Ms. Barnhill, since the inception of this case or for any other case.
The results come in, and things get weird fast. The test is negative for a bunch of substances, but not marijuana, because they don't even test for it anymore. Then the prosecutor drops a little nugget about something she allegedly said downstairs. And now the judge wants answers directly from her. What follows is one of those courtroom moments where you're practically yelling at the screen. She admits she smoked marijuana the day before. Voluntarily. The judge's eyebrows immediately launch into orbit. Did she really think that answer was going to help? Because now the defense has to step in and somehow fix this.
I appear before the court on her behalf today, equipped with a pleading I received from the prosecuting attorney's office titled People's Emergency Motion regarding bond. It's new information, to be sure, but I don't see any allegations. No one is, it's being deduced without evidence that somehow Ms. Barnhill is responsible for giving the child marijuana or allowing the child. And I don't think that there's any evidence to support that whatsoever. What the problem here is marijuana. It's not depriving these 3 children of their mother. The children didn't do anything. She's got 3. One, the oldest is 8 years old. School just let out for the summer. She has a 2-year-old, and of course, this youngest one, 1-year-old. Ms. Barnhill has indicated to me that she does have an apartment, and she does have an adult staying with her, share the rent, and so forth, who could act as a supervisor of those visits if the court saw fit. If you take the marijuana out of the equation, we don't have a bond violation, we wouldn't have a hospitalization.
Trayshawn, I heard he made the call, whatever is concerned. He's also the person that didn't get the memo about CPS telling me I have to have someone else. Like, okay, I gave them names, numbers, last names of my cousin, other people that could take my child for me in the meantime. He called my mom. My mom is his babysitter. That's why my children were with them when I was in jail, because I couldn't watch them, so they have my mom take care of the kids if I can't.
This is the mom who leaves marijuana around.
Yeah. And then you told me that she had to be the supervisor.
Well,
I
nobody
wasn't-
explained to me about her marijuana use, that it was in the house or any of that. And that was supposed to be verified by, I believe, either pretrial services or probation. So we'll deal with that. What else?
And I'm not keeping he gave us the kid. That's why we have the kid right now, because he gave us, her. So I'm confused as to, she's saying all this stuff. I wouldn't follow the safety plan. Yesterday, I helped the lady make the safety plan. So I'm confused.
So do we need to have a hearing or get her on the phone? We can ask, because if you lie to this court, it's 93 days contempt, 93 days under $7,500. I suppose you don't have the $7,500. I don't have it either, but you got 93 days. Additionally, if the father came over and asked for the child and there was an issue, why didn't you give the child back to the dad?
We did. I'm confused. He never
Well, I'm
asked for
confused.
this child.
Okay, we can have a hearing. I got all afternoon. And well, let me just
I'm just
ask
trying
you,
about
if you
when
interrupt
she
me,
was
it's
in
93 days.
Fox, you don't, okay? You only speak when she asks you a question. That's
Thank
it.
you, counsel. So I am unclear why it took the father to get this child or your mother to get this child.
So the defense attorney jumps up and basically says, look, take marijuana out of the equation, and we don't have a problem. Sir, that's like saying if you remove the water, the Titanic had a pretty smooth trip. Then the defendant starts pushing back against the CPS claims, saying she followed the safety plan and everybody misunderstood her. The judge listens, but you can see it. That slow head tilt, that stare. That's the universal courtroom sign for, I'm not buying what you're selling. And then he asks the question everybody wanted answered. Where exactly were you when this child got into trouble?
To the hospital, and why you didn't call or take that child to the hospital.
I did. I'm the one that took her to the hospital. I saw something was wrong, and I'm like, I should take her in, shouldn't I? And she's like, yeah, it looks like she's having a seizure. Like, we didn't know what had happened. So I'm like, okay, I'll go take her, And I took her to the hospital.
Child is what, 1.5 or 14 months? How old?
Yeah, 14, 15 months, yes.
Where were you? I've got 5 kids.
I
They're
was-
14 months. I'm following them around. I know whether they're getting into something or not. Why is that child allowed to go in your mother's bedroom where you know there's marijuana and then ingest probably gummies that she thought was candy? Where were you?
I was doing the laundry. I was in the laundry room.
You don't know the exact moment the child may have ingested something.
Yeah, but that's the only time I took my eyes off her, was when I was in the laundry room. I was with her otherwise. So.
Anything else you want me to know?
There's a bunch of stuff I want you to know, but nobody really cares what I have to say.
Ma'am, I'm here, I'm listening, I've asked you. If you don't want to speak, then don't. But if you do have something to say, I always take the time to listen. So what is it you want me to know? Okay, on behalf of the people.
Your Honor, CPS is not it's the real problem. Well, I think this defendant is the real problem. Not marijuana, no. we have all these adults in the house and nobody's watching a 14-month-old. That's absurd. What, does she do laundry for half the day? Give me a break. Your Honor, CPS tried to safety plan with her and said, put the child in a relative's home. She gave them, here, I got the notes right here. She emailed me the names of Marcy Guzman and Vanessa Guzman. The phone number provided was X. She was asked to provide any other last names and addresses where the child would be present. Several hours later,
Thank you.
she stated Conrad, stated there was no other last names. The phone number was not a working phone number, and the address is the address of her mother. It was clear Ashley was not willing to cooperate or comply with a safety plan. She worked with CPS yesterday on a safety plan, another one, because she wouldn't do the other safety plan, and CPS won't do anything. That's the problem. So sure, she's working with CPS, right, because she says, oh, I'm not gonna give my kid to this fake relative or this address of my mom's house. And CPS says, okay, well, I guess we don't have any, we don't have any backbone, so we'll just do whatever you want. So you want to get our paperwork in order, whatever. So they don't do anything. So now she says, well, I'm complying with the safety plan. That is it. And that is so inaccurate. It's ridiculous.
And here comes the explanation. According to her, she was doing laundry. That's it. Laundry. Meanwhile, a toddler somehow wanders into a room with marijuana products and ends up hospitalized. The judge's face freezes for a second like his brain just hit a loading screen. Then the prosecutor comes back firing. Hard. He starts reading CPS notes, questioning the relatives she named, questioning the phone numbers, questioning everything. At this point, it feels less like a defense and more like damage control. And when the prosecutor finishes, the room has completely shifted, because now it's the judge's turn.
I don't have anything else to say.
Thank you. Counsel, anything further?
Your Honor, I have no information with respect to a safety plan or CPS involvement. I don't know. I'm unable to assist the court in that regard. But it is, I think, significant that it was Ms. Barnhill herself who took that child to the hospital. And the biological father, there was a no contact order, so it would be improper for her to notify him by telephone or to have someone else in her place notify him.
No physical or emotional abuse, no compliance with CPS orders or recommendations, no ability to disobey or not comply with CPS or family court orders. And there was no appropriate supervision of the child. All of these things were ordered, and what I get is a no, 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 which means 0 plus 0 plus 0 plus 0 plus 0 equals nothing. What I do have in this equation is a lot of excuses, a lack of accountability and responsibility. You're crying now, but as you sat over there, you did this, and were shaking your head and making fun of what was being said. And downstairs, it was reported, and I heard your attorney say, don't say anything. Well, it comes back to me, your attitude and what was said down there. You don't really care, man. The root of the problem is you. When you have a child, laundry, cooking, whatever, you make sure that child is safe. You put him in a pen, in a walker, you bring the laundry out to the child, you bring the laundry and the child together, bring the child to the laundry room, show them how to fold. They might toss a few washcloths or something and have fun with it. There's lots of things you can do to make sure your child is safe, and you have not done that. The charges that I have in front of me are very, very serious. I am revoking bond, and in regard to the probation file, I don't know what I will do on that, except that I am extending it to the full 36 months.
Sai, you know that moment when someone keeps digging and suddenly realizes they're holding a shovel instead of a lifeline? Yeah, we're there. The defense tries one last push, but the judge isn't focused on excuses anymore. He's focused on accountability. Every explanation gets swatted away. Every justification hits a wall. Then comes the body language. Leaning forward. Direct eye contact. Zero patience left. And when he says the root of the problem is her, you can practically hear the air leave the room. Then the bomb drops. Bond revoked. But wait, he's not done yet.
You will not have any contact with the victim, any phone calls or other contact with your mother or with your children over the telephone will be appropriate, or that will also be denied.
So I can't have phone calls with my mom or the kids?
You can, as long as they're appropriate. Keep in mind, the people listen. And if you do anything that is inappropriate, I will suspend any communication outside of the jail.
Judge, I'm asking that you have a no contact with the victim in this case, which is also the 14-month-old. I understand if you want to allow contact with her other children via the phone call, but
That's fine. Yeah, I think that's appropriate. So no contact with the 14-month-old. I don't know how much they communicate anyway, but we have to keep children safe. Children don't have a voice. As a parent, you have a higher responsibility to care for them. You are their voice. You are their safety net. I haven't seen that man. I also, while you are in lockup, we're going to get you a psychological evaluation, and the children then will remain with the father. Children shall not be watched by any family member. The children now will be in the sole care and custody of the father.
thank you, Your Honor.
And the grandmother is not allowed to be the daycare provider. He'll have to find other means, and I assume that's what he will do. It seems to me that he's trying to do that.
Thank you, Your Honor.
There's the family court involved, so they can work with him further if he needs. Thank you.
Now we're in full ruling mode. No contact orders. Psychological evaluation. Custody staying with the father. Grandmother removed from caregiving duties. One by one, the judge locks every piece into place. And then he delivers the line that really lands: children don't have a voice, so parents have to be their voice. The courtroom goes quiet, because there's really nothing left to argue. Case closed. Consequences delivered. And if there's one thing this hearing proved, it's that judges can spot excuses from a mile away. If you enjoyed the breakdown, hit like, subscribe, and stick around for the next wild courtroom story here on Case File USA.